Hi there. I'm attorney Alex Meeks, owner and founder of Acorn Law, a law firm in Central Maryland that's dedicated to helping busy parents and families get their affairs in order. Now, this is an important task for any family, but it's especially essential for families who have a beneficiary with special needs. This is a topic that's near and dear to my heart because I have a number of loved ones in my own family who need this kind of special planning. Unfortunately, there's a lot of rumors circulating about how to treat these individuals in estate planning, and a lot of them are not good, you guys. So the purpose of today's video is to go over the biggest pitfalls, the worst advice that I see, and make sure that you guys don't make those mistakes. Let's get into it. Before I go over those 3 big pitfalls, I think it's really important that we take a moment to ensure that we're all on the same page about exactly who it is we're talking about today and why. To be clear, not every individual who identifies as or is identified as special needs requires the kind of planning that I'm discussing in this video. The individuals who we need to be really careful of are those who already qualify for or might in the future need government needs-based assistance. These are programs like Medicaid and Social Security. Why is it so important that we're careful when addressing people who may need these kind of programs? Well, it's because in order to qualify and in order to maintain qualification, individuals have to keep their assets super low, assets in their name. So an inheritance of a large amount can really mess up someone's benefits. And indeed, they might need to spend down that entire amount before they can get their benefits back. There's all kinds of rumors circulating about the best way to do this. Let's jump into that first pitfall now. One piece of advice that families often get is just to disinherit the special needs individual entirely. I can understand the allure of this as people really are nervous not to jeopardize those public benefits. But I'd say going this route is really short-sighted and places the special needs individual at a real disadvantage. Being left with only public benefits to rely on is a tough spot to be in. The second big pitfall that I see families make is to rely on siblings or other family members as a sort of workaround. The theory here is leave an inheritance of a larger amount to a sibling or another relative with the understanding that that person will provide for the special needs individual kind of on an as-needed basis, but that'll keep the funds out of the special needs individual's names. It's a good idea in theory, but I really caution people against this. There are so many ways for this to go wrong. What if the relative who you've left the money to predeceases your special needs beneficiary? What if they become incapacitated? You also have to consider that that person could marry, the funds could become marital, and then if there's a divorce, they could lose some of those funds in the divorce. Another potential outcome is that person becomes indebted to someone and a creditor accesses the funds. This is not a good way to go. Even in a family where you really feel you can rely on someone, there's just too many ways for it to go wrong. If you've made it this far in the video, you've made it to the third and final pitfall, which I'm calling just wait and see. Who among us isn't sometimes guilty, especially when a situation seems daunting, of just burying our heads in the sand and hoping for the best? So let's play this out and just see what would happen if no provisions were made at all and your special needs beneficiary inherited. One option that would be available would be just to forego government needs-based benefits entirely and rely instead on the inheritance funds to provide comparable services. Another option would be to spend down the assets as quickly as possible to get them down under where they need to be for your beneficiary to qualify again for their benefit. Now, one other option that would be available to your beneficiary would be they could set up a first-party supplemental needs trust. This trust would protect those assets from the government during your beneficiary's lifetime and not jeopardize their benefits. However, it's essential to also understand that these trusts must include a Medicaid payback provision, which means that when the trust closes out, that any funds that are left over in the trust would need to be paid back to Medicaid to cover any expenses that were paid out during your beneficiary's lifetime, which in most cases means that the trust funds are then drained and not available for other beneficiaries. Thank you so much for listening. I hope that you found this video helpful, and I hope that it helps at least 1 or 2 people out there to avoid these common pitfalls. If you made it this far, you probably want to hear what I do recommend for people in this situation. Well, I really highly recommend considering a third-party supplemental needs trust. This is a trust that you set up during your lifetime for the benefit of your special needs beneficiary. It allows them a better quality of life because they'll have access to those funds without jeopardizing their government benefits. It also has the added facet that, unlike those first-party trusts, there's no Medicaid payback provision. So when you set this trust up, you can also direct how you want any leftover funds to be distributed, which means your hard-earned money doesn't go straight to the government. I love setting these up for people. I think they're such a fantastic tool to ensure a better quality of life and to protect families' legacies and assets. If you're interested in talking more about this or any other legacy planning, please don't hesitate to go to my website and set up an appointment. I'd love to talk to you, and I'd love to help.